My name is Katharina BOELE-WOELKI and I have contributed to the book with an article about the origins and development of European family law. What is covered by European family law? Family law is basically national law, but it is increasingly influenced by international and regional legislation and decisions of supranational courts. Hence, over the last 25 years, an independent field of law has developed within Europe, which we refer to as European family law. In particular, within the European Union, many questions regarding cross-border family relations are unified by European regulations, whereas the harmonization of substantive family law is gradually taking place in various areas. European family law has gained great importance in legal practice and simultaneously has received much attention in the academic world. In defining the concept, the starting point should be that comparing different family systems, trying to find similarities and differences, and searching for inspiration either for improving one's own law, for finding a common core, or the better law should not be hindered by organizational legal borders. Hence, when referring to European family law, Europe should not be confined to the European Union, but should cover the greater Europe, to which the countries of the Council of Europe belong. My contribution tries to explore the decisive features of European family law. Of which elements does it consist? Who has contributed to its creation? Who influences its content? And how will it develop in the future? Before discussing the main contributions to the area of European family law, I briefly address two fundamental issues. First, the ideals, moral concepts, values, standards, and their changes over time. And second, the question whether we need more unified and harmonized family law in Europe. In the following, I'm indicating what contributions have been made so far by the various actors, such as the global and regional organizations and the legislation, the jurisprudence of the two European courts, European scholarship and European conferences and research projects. This is the past and the present, where we find the beginnings for the future developments. They form the basis for some final considerations. To begin with, I would like to reiterate that the unification of private international law in important areas of family law laid the foundations for the emergence of European family law. At the same time, European freedoms and the European Court of Human Rights have contributed to the harmonization of family law in Europe. This development is irreversible and irresistible. Consequently, it will shape the future. Regarding specific areas of family law, I focused on the following topics. First, the recognition of same-sex relationships, which has caused intense debates about new family forms. Within the Union, the right to freely move within the member states, Article 8 of the European Convention on Human Rights and the European Charter on Fundamental Rights are guaranteeing equality of all couples. Already today, we can speak of the right to relate. In a few European jurisdictions, the next step towards putting same-sex couples into the same legal position as different-sex couples as regards children have already been taken. They may adopt children, and in some jurisdictions, the co-mother, who is a spouse or registered partner of the birth mother, is considered the second legal parent if the child is born into such a relationship. More jurisdictions will follow. Second, medical advancement poses new questions, for example, whether a child can have more than two legal parents, and whether multiple parenthood can be based upon an agreement between, for example, a lesbian couple and a donor. Apart from this situation, parentage law is challenged to provide solutions not only for legal, but also for biological, intended, and social parenthood. In this context, surrogate motherhood should be addressed. Courts in different European countries have been challenged to decide on whether surrogacy agreements or the status as legal parents which commissioning couples have obtained abroad should be recognized. In the best interest of children born out of surrogacy, many courts have rightly decided that they should neither be parentless nor stateless. Third, the consequences of divorce and separation for children will continue to demand our attention. Alternating residence of children after divorce and relocation of children with one of the parents within or outside the home jurisdiction are two relatively new issues which, due to the recognition of joint parental responsibilities after divorce, are intensively discussed all over Europe. In particular, the courts have formed the law. Also in this field, the comparative perspective provides fruitful information. Fourth, the estimated number of de facto unions in all European countries has steadily increased. In the vast majority of European jurisdictions, however, specific legislation is missing. In achieving greater legal certainty, the model law on de facto relationships drafted by the Commission on European Family Law could serve as a good source of inspiration for national legislators in their quest to protect the weaker party in such a relationship. Finally, on a more general note, I think that comparative legal studies, which not only give us access to foreign family systems, but also help us to find the best solution, are indispensable for the development of European family law. Thank you for your attention.